Fletcher Tilton, the team is here. I'd like to again thank them for sponsoring this event and for taking the time to share their expertise with us. And now I'd like to introduce Kirk, who's the president of Fletcher Tilton, and he'll say a few words about the company and then introduce the rest of the panel.
Good evening. Thank you, Joe, for the introduction, and thank you for Venture Forum. We're delighted to be here tonight and to sponsor this event. Welcome to Legal 101 for entrepreneurs, which we're going to touch upon some basic legal issues that touch upon the area of entrepreneurship and startups. As Joe mentioned, I'm Kirk Carter. This year I have the pleasure of serving as president of the law firm Fletcher Tilton PC. We're a full-service law firm with nearly 50 attorneys across 6 offices. Our main office being here in Worcester, and we have offices in Framingham and a few in the Metro West area, heading south down towards the Cape as well. We're one of the nation's oldest law firms, and one of the country's most successful law firms. For nearly 200 years, we have been advising entrepreneurs, business leaders, industrialists throughout central Massachusetts, guiding them through the legal challenges that they face in their businesses from day to day. Like most successful enterprises, we haven't survived 195 years by standing still and resisting change. We've embraced innovation in the legal field and been leaders in providing specialized, cost-effective legal services and solutions to our clients. It is said that entrepreneurship is the refuge of the troublemaking individual. Those who seek to upset the apple cart, to disrupt, to change the way we see and do things. Such disruption and troublemaking requires lawyers to keep you out of trouble and to help guide you along the paths of what is trouble and what is permissible, as well as other professionals, such as financial advisors, accountants, venture capital folks. Today we have a great panel of attorneys here whose expertise spans a number of areas that relate to or are relevant to the world of startups and entrepreneurship, including my own. Although I'm not doing a formal presentation, I head up our firm's immigration practice group, where I manage a team of attorneys and paralegals who assist foreign nationals and technology companies primarily in navigating their ways through the complex immigration laws, assisting them in reaching their goals and aspirations. We also work with investors who may be investing in a business here to obtain a green card or residence here in the United States to secure their future. Sticky papers. Our panel today includes Jess Oyer, who is one of our newer attorneys in our litigation group, who's going to talk to you a bit about how best to work with attorneys, how to find them, how to engage them, how to pay for them, how to get the most out of your relationship with an attorney. Next, Dennis Gorman, who is a member of our corporate and estate planning group, who has a wealth of experience representing businesses throughout central Massachusetts through all various stages of their organization, from formation to expansion to growth, succession planning, and sale. He's going to speak to you about business entity selection. What are the pros and cons of various types of entities and how to find the right one for what you're looking to do. Bobby Hazelton, who specializes in intellectual property law, will then provide you with some basics on intellectual property and guide you as to what to look for in the agreements, the IP agreements that you're dealing with. Lastly, Joe Bartulis, who heads up our employment practice group, is going to discuss with you the issues around engaging others, hiring people. As your business expands and you need the assistance of others, he's going to provide some guidance on how best to comply with important labor laws. We've allowed some time at the end of the program to take questions. I believe that the form has been passed around for you to fill out some questions. Throughout the presentation, if a question comes to mind, rather than stopping and interrupting the presentation, we'll take those all at the end. But if you could pass those up to me or to Celia in the back there, waving, or Christina, who is over there. She'll get them up to me, I'll get to the appropriate person, and as we get to the end of the program, we'll take some time to answer your questions. So with that said, our first presenter is Jess Oyer.
So thank you all for being here tonight. And thank you, Kirk. So my name is Jess Oyer, and I'm a litigation attorney. As a litigation attorney, my primary goal is to get my clients out of litigation as painlessly as possible. The most painless way to approach litigation, in my opinion, is to avoid it entirely. Now, there are certain situations when litigation is necessary and appropriate, but when it comes to avoiding litigation, adequate preparation and preventative measures are key. To ensure that preparation and prevention, it's important to seek legal counsel as early in any business endeavor as possible. With that in mind, I want to talk to the aspiring entrepreneurs here tonight about seeking legal counsel. So the first question you want to ask yourself is, when is it appropriate or when is it necessary to seek legal counsel? In other words, when is it necessary to reach out to attorneys and to set up your initial consultation in order to discuss your idea or your business plan and how best to roll that plan out from a legal and practical standpoint? And the answer is at the inception of your marketable idea. Now, I don't mean to suggest that the moment the light bulb goes off in your head, you immediately call up your attorney. But when you think your idea is marketable, whether that idea is for a new product or a new service, once you're ready to act on that idea, to discuss it with your peers, and to potentially start putting together a team of partners, then you should be thinking about engaging an attorney. And the role of the attorney is to navigate you through existing laws and regulations, to protect you and insulate you from liability to the extent possible, and to help you clearly define your business relationships, whether those relationships be with partners inside the business or with vendors or purchasers outside the business. Attorneys are trained in these areas, and despite their reputation, they do provide advice and services which will be instrumental in ensuring the health of your new venture. Every action you take with your new idea potentially exposes both you and the idea itself to legal conflict, and the attorney's role is to help you avoid that conflict. If any of you have seen the movie The Social Network, you know how Facebook was plagued with legal troubles at the outset because it was eventually developed from verbal deals among friends and classmates. So much like a doctor, if used properly, an attorney should protect your idea from these sorts of troubles and keep it healthy, guiding it from inception to market, rather than just stepping in to help once problems have already arisen. Now, some of the key decisions you might face, which should trigger in your mind the question, is this something that could benefit from advice of counsel, are listed here on this slide. So any decision to hire employees or engage with partners. This is the point at which you're establishing relationships, and it's important to establish the roles, responsibilities, and the rights of each person with clarity and legal sufficiency. Any contract action. So here again, you're engaging in a certain type of legal relationship, whether it be inside or outside the business. And it's important that you establish and understand the rights and obligations of each of the parties to that contract, and that you avoid certain potentially harmful clauses and provisions. Any transfer of assets. Any such transfer is bound to implicate legal obligations and rights, and it's important to understand who bears the burden of those obligations and who possesses those rights. And the point at which you're seeking investment or creating funding arrangements, again, you're going to want to know how that investment is structured, and you're going to want to know what rights and obligations the investors have, what rights and obligations you have, and you're potentially going to want to try and limit the rights and obligations of the investors. And that takes us to the next slide. And many of you may be thinking to yourselves, why is it necessary to seek advice from an attorney who is probably going to charge me a lot of money when the digital age has brought us a variety of online legal services? And the answer is pretty simple. So the attorney should be able to provide you with personalized, contextualized legal service. The attorney will engage with your idea, understand it, understand your goals with respect to the idea, and work with you to realize those goals. Additionally, you'll be able to select an attorney who specializes in the laws of a particular jurisdiction and who will be capable of accounting for laws in other jurisdictions if, for example, you're trying to incorporate a business in Delaware but operate primarily out of another state like Massachusetts. Attorneys are also accountable for their work, and you can work together with your attorney to resolve issues that might arise during the course of their representation. The short-term downside of hiring an attorney is the upfront expense, but an ounce of prevention is worth a pound of cure, and we'll come back to that a little bit later. Now, with respect to online services, these are necessarily one-size-fits-all services, and these are most often used to obtain boilerplate documents of a general applicability. They're not individually tailored to your specific needs. They do not necessarily account for all of the possible jurisdictional nuances, and there is little to no accountability of the service provider. The real benefit is that they're cheap and they have little short-term cost, but the long-term cost can be great. If protections are inadequate or the relationships are ill-defined by these service providers, you can find yourself in a legal dispute which costs far more down the line than it would have cost to adequately protect against at the outset. So I want to provide you with some examples of how mistakes can be made when business owners and individuals don't seek preventative legal advice. And these are examples which I've come across in my practice, either anecdotally from other attorneys or otherwise. Now, in the first example, one individual attempted to sell a rather large commercial property without the use of an attorney. And he was successful in doing so. The sale went through and he received the purchase price that he wanted. However, months later, an attorney was looking through the sale documents because of an unrelated matter, and the attorney noticed that this individual would have been eligible to recoup significant historic utility overpayments to the tune of approximately $1 million. But at that time that the attorney noticed this oversight, it was too late to do anything about it. So here you have an example of an individual who doesn't hire an attorney, actually achieves his desired goal, but unbeknownst to him, at the time that that goal was achieved, he lost out on a potential windfall. Second example, there was a particular family that owned a group of closely owned corporations. And they set these corporations up in such a way that there was a slush fund that each corporation had access to. So anytime one corporation wanted to loan money or borrow money from another, they would sort of funnel the money through this slush fund. And no attorney was ever consulted when setting up this arrangement. And when one corporation was later sued, the existence of that slush fund resulted in the separate corporate entities all being treated by the court as a single corporation. Now, the purpose of setting up a corporation is to limit the corporation's liability to the particular corporation's assets. So this mistake essentially negated the protections that are intended to be afforded by the corporate form. In the third example, there was one individual, or one company rather, who hired an accountant rather than an attorney or a combination of the two to make certain changes to the company's registration status. The accountant accidentally dissolved the corporation in the process of submitting documents to the government, and once dissolved, the corporation couldn't be resurrected. So the business essentially had to reincorporate at significant cost to the owner. Now, each of these examples simply demonstrates that involving an attorney early in any key business decision can help you avoid significant and unnecessary costs in the future. So we've covered why it's important to seek legal counsel, but some of you still may be wondering how exactly to go about seeking that counsel. And in today's marketplace, it's always important to do some initial legwork of your own. And what I mean by this is that you should game plan your first meetings with attorneys and come prepared. When you walk into your first meeting, you should have a clear understanding of your needs and your goals. And at that first meeting, it's also very important to come prepared with certain written materials. For example, I would recommend writing down and bringing a general description of your idea or business venture, a statement of your legal needs, an outline of your goals, essentially meaning what you're looking to have the attorney accomplish for you, And I would also recommend bringing all relevant documentation that you have in your possession and even create summaries of relevant issues and timelines where applicable. I can't tell you how much more efficient I become as an attorney when a client comes through the door and attends a meeting and is organized and prepared and brings all that sort of documentation with them. It's very easy after a meeting is over to get sidetracked with a phone call or some other client, but if you have all that written material with you at the same time, it's easy to turn back and refresh your recollection. You should also have an idea of which attorney might best serve your needs. You want to think about what type of specialized legal expertise you're seeking, and you want to search for an attorney that has a demonstrated experience within that field of expertise. The main objective here is to increase the efficient use of your lawyer's time through your own organization and preparation. And choosing the right legal counsel can be difficult, but again, it's important to do a little legwork. First, it's important to realize that, like in many fields, there are many different types of attorneys who specialize in various areas of the law. And there are also what we refer to as generalists who practice in many areas of the law. When choosing an attorney, although there are obviously competent generalists, you'll likely want to choose a specialist over a generalist. A generalist may be able to provide you with a wide range of services, but his or her knowledge and experience in any one field might not be quite as thorough as a specialist who spends the majority of their time exclusively in a single field of practice. And this is especially true when you're dealing with entrepreneurs who are in sort of highly technical fields. So you want to research specialists in the field in which you're seeking counsel, speak with peers and mentors, and get an idea of who you think might best serve your needs. Once you sit down for an initial consultation, it's important for you to understand exactly how that particular attorney plans to provide his services. And it's important to set his or her expectations with respect to your budget, your goals, and any specific deliverables you expect her to provide. With respect to budget, you want to request a detailed fee estimate, which will lay out the costs the attorney estimates will be required for her to fulfill what is now your statement of work. So once you go in there with your goals, the attorney will essentially turn those goals into what is called a statement of work, and that will become her sort of outline for what to provide you going forward. You'll also want to understand the basis on which the attorney will be charging her fees, and there are several common forms of billing in the legal field. So first, there's billing based upon, I'm gonna go not in the same order that these are written. First, there's billing based upon a contingency fee. And this is not very relevant to the discussion here tonight because this arises mostly in the context of personal injury cases. But I mention it only because it's one of the more commonly used billing arrangements, and you've probably all heard of it before. There's also billing based upon an hourly fee, and this is typical of services like civil litigation. So if you find yourself in a contract dispute down the road with a partner or somebody outside the business, then this may be more relevant to you then. There's also billing based upon flat fees, and this is typical for services related to drafting certain types of contract documents, documents related to incorporation, non-disclosure agreements, etc. So each would come with sort of an individualized price tag based on the nature of the contract itself and what you're looking for the attorney to do. And you'll want to be sure to understand not only the attorney's overall estimated service budget, but also these sorts of methods by which he or she plans to bill you for those services. In sum, the more detail you bring to the meeting, the better able you will be able to contribute to the discussion with the attorney to help him or her understand the unique nature of the services you seek, and essentially to guide him to be able to better serve your needs. And during the course of that meeting, you should be sure to ask the important questions so that you have a clear understanding of how the attorney is going to fulfill your scope of work and what the associated budget and fee arrangement will be. Following this simple advice will put you in a great position to move forward with hiring an attorney and obtaining the advice and counsel you seek. Thank you, and now Dennis Gorman is up next.
Good evening. I'm going to spend 15 minutes or so, maybe 20, talking about choice of entity. I could probably spend 3 hours doing it, so it's going to be somewhat abbreviated. If there are things that are unclear, just jot down a question and we'll have a half an hour to cover it, hopefully at the end. Basically, what I'm going to talk about is liability protection, tax differences, and then a little bit on estate planning differences of various entities. So a lot of people are under the misimpression that if they are the sole employee person rendering services for a venture, that incorporating is going to be of some sort of a benefit to them. And largely, that's not the case. If I don't have any employees for which I might be personally liable for, and if I don't have any partners that I might be liable for, one can never escape liability for their own tort. So if I run somebody over in a car, or if I defectively design a machine that ends up cutting somebody's arm off, if I'm the one that designed it, I'm going to be personally liable no matter what. So setting up an entity is not going to protect me from that. What it does protect you from is potential contract liability. But frankly, if you enter into a lease with a landlord and you're a small corporation, for example, and you haven't been around very long, chances are the landlord's going to make you personally guarantee that obligation. And frankly, if you go get a line of credit at a supplier, same thing. So if contractually everybody's making you personally guarantee something, what are you really getting away from in terms of incorporating or doing an LLC? But, so, once you have multiple employees and multiple owners, then clearly you need to have an entity, because multiple owners are all, if they were just unincorporated, would be liable for each other. And then the operators of a business are always liable for that, any liability stemming from their employees. And people get very nervous about that. So that's when you would consider setting up an entity for liability protection. The other thing is, oftentimes, that aside, you might have different classes of owners, and you might have varying levels of investment, capital investment, which would dictate some organization, either a corporation or an LLC, in which you memorialize that you're getting 20% and I'm getting 50% and he's getting 30% and whatever. And you can't really do that as a sole proprietorship. Okay, so the tax treatment is really where the rubber hits the road. And just so you know, by setting up an entity, you're not going to get any better tax treatment than a sole proprietorship, because that's just a Schedule C or a Schedule E on your 1040, so it's one level of tax, and it frankly doesn't usually get better than that. People just don't want to pay two levels of tax. So it's really the liability issue that drives people to incorporate or do an LLC. But let's talk about the differences and drill down a little bit. So if you're a sole proprietor, you're obviously subject to income tax on on the net income that you earn. Unless you're a real estate enterprise, chances are you're going to be subject to self-employment tax on all of that net income that ends up on your 1040. So that is an issue, and hold that just for a second. A C Corp is simply a corporation that does not make a Subchapter S election. Okay, so it's just a regular corporation taxed under Subchapter C. Now, typically, the people who own corporations will take W-2 wages, and in fact, a lot of the accountants prefer to use a C corporation because they can basically allow the corporation, the owners, to take a limited amount of wages and pay some payroll taxes, and then leave the rest of the net income inside the C Corp and pay taxes at the lower corporate levels, let's say on below $100,000. I'll talk about it in a second, but it's always a danger when you get to an exit event. The problem with a C Corp is if you liquidate it, or if you sell it, and then some buyer comes along and they buy all the assets of the corporation then pays a tax at the corporate level. And if it's an exit event, it's usually a drastic number. And then when you try to get the residual cash and whatnot out to the owners, it's a dividend taxable on the individual's personal return, so you're basically paying a double whammy. The other thing with corporations is that if people contribute appreciated assets to a corporation, this is also going to apply on my next slide for C Corps, unless the stockholders or the individuals get back stock at least 80% or more of the company, then it's going to be treated as a taxable event. And so therefore it triggers tax at the shareholder level when they put the appreciated assets into the corporation. And similarly, if you take assets out of a corporation in kind for whatever reason, that also triggers a gain at the corporate level. So if you're a C Corp, you're going to pay tax to the state and federal government at the corporate level, and you may also pay another level of tax at the shareholder level. So C corporations are very dangerous. S corporations are probably the most common. It's simply a corporation that makes a subchapter S election to be basically treated as a flow-through entity for tax purposes. So the corporation files an informational return, but it doesn't necessarily pay a tax to the government. There are some state taxes if you're over a certain amount, but generally speaking, at least with the IRS, it's a flow-through entity, which means the net income at the end of the year just goes on a K-1 form, and it goes out and the shareholders report that on their individual returns, and so you essentially pay one level of tax, which is certainly better than the C Corp. Now, the K-1 income that you get, so typically let's just use an example. You have $100,000 of net income that the corporation's generated. The shareholder takes $25,000 as a W-2, so now you have $75,000 net income that the S Corp has. The 75 ends up on the shareholder's tax return. That 75 of flow-through income is not subject to self-employment tax, okay? So for that very reason, a lot of the accountants would prefer to use a corporation because that flow-through income is not subject to self-employment tax. You still have the same issue as I pointed out earlier about contributions of appreciated assets or distributions of assets to or from an S Corp. That also triggers gain at the corporate level and may generate another level tax event at the individual level. With a subchapter S, the shareholders must be U.S. citizens or resident aliens. So that's one of the key distinctions between an LLC and a corporation. LLCs don't have this requirement. The limited liability company, I'm sure many of you are familiar with them. It's a flow-through entity, slightly different type of flow-through entity. They're taxed under a different section of the Internal Revenue Code. You don't take wages. The owners do not take wages from a limited liability company. They're really called guaranteed payments, but they're tantamount to wages. Guaranteed payments are subject to self-employment taxes. Now, as I mentioned earlier, the K-1 flow-through net income that comes out of an LLC to the owners is generally subject to self-employment taxes, with the exception of if it's a real estate entity, then it's not. But if it's a regular operating business, then the general rule, it is. So that's why the accountants generally don't like to see LLCs, because you have that incremental self-employment tax on that income that they're not otherwise subject to on the S Corp. However, there's an IRS proposed regulation which has been out there for a while, and you can actually set up multiple classes of members, and you can give out a small portion of membership interests that will be subject to self-employment tax, and then a much bigger percentage of a different, a non-controlling percentage, which will not be subject to self-employment tax. So there are ways around it. You just have to drill down and just do a little bit more work if that becomes an issue. One of the nice things for LLCs is that if you only have one member, you don't have to, the IRS allows us to disregard it for income tax purposes so that you don't even have to file a tax return for an LLC with only one member. You can just put the numbers on the owner's 1040 on a Schedule E or C, and that'll probably save you $1,000, $1,200 a year in tax prep fees. The last point is contributions and distributions of assets, appreciated assets, into or out of an LLC generally do not trigger gain. Another key distinction. When people have patents, intellectual property, other assets that they're transferring in, generally speaking, it's not going to trigger gain to the shareholder. So when that is an element that's present, then you need to probably take a real close look at doing an LLC over a corporation. Jumping back to creditor protection just for a minute, in my view, LLCs provide a higher level of creditor protection than corporations for a couple of reasons. One is that potentially officers and directors of a corporation have liability. It's not uncommon that directors and officers of corporations get sued for various reasons, and that's why not too many people join boards of directors unless they know that there's directors and officers liability coverage. But it's now, and furthermore, if I own stock in a corporation and I happen to run somebody over in a car and they get a judgment against me personally, they can get my stock in a corporation because the law allows that. So contrast that with the limited liability company, and the membership interests in an LLC cannot be seized by a creditor. That's right in the statute. The best they can do is if they get a judgment against Dennis Gorman, they can go to a judge and they can get a charging order which says, if and when any profits get distributed out of this LLC, I can intercept them. But if I control the LLC, I'm just not going to make any distributions to Dennis Gorman. And that's usually a good bargaining chip to settle the case. If that's all I have to get and they know I'm not going to turn the spigot on and let it come out, then I can usually bargain with the creditor and get rid of that liability at a substantial discount. And furthermore, the LLC statute specifically says in it that no member or manager shall have any personal liability for any of the limited liability company's obligations. Right in the statute. Makes me feel a lot more comfortable than case law and whatever else is out there on the corporate side, okay? And finally, we've said it already, but the sole proprietor is fully liable for everything that has to do with the business. So, what are the fundamental differences for the various entities? Well, the sole proprietor, there is no entity documentation because you immediately start up on day one and just conduct your business. There's no entity. You might have to do a DBA filing, a doing business as, so if you're not doing business, holding yourself out to the public in your exact name, then there's technically a requirement that you have to register. If I'm doing Acme, it's Dennis Gorman, but it's really Acme Painting. Well, the public doesn't know who Acme Painting is, and the DBA requirement, filing in the town that I'm doing business with, allows the public to fine me if they have some issue with me. If you don't do it, there's a fine, like a per day fine. Now, even though you're a sole proprietor, chances are you would get a tax ID number for the business because you don't want to have your Social Security number floating around out in public. On the corporate side, we prepare articles of incorporation, and we file those with the Secretary of State. Typically, you'll have bylaws that govern, when you have your annual meeting, how many directors get elected, and the governance matters. Corporations obviously get their own tax ID number. You do that with the SS4. We typically prepare stock certificates, and there is a requirement for corporations to have annual meetings or at least consent minutes in lieu of an annual meeting. On the limited liability side, you simply file a certificate of formation with the Secretary of State, and that is what creates you. It's a good idea to have an operating agreement, which is basically the agreement that governs the rights and obligations of the various owners of the LLC. You would typically file a tax entity selection. An LLC, in the new friendly IRS world, you can actually choose how you want to be taxed. So you could do an LLC and elect to be taxed as a C Corp or an S Corp or a partnership, which is the typical way LLCs are taxed. And we typically make up membership certificates for LLCs as well. I just spent a brief moment on estate planning for entities. So a lot of estate planning gets done around succession planning in entities, and it's basically done with gifting to the next generation. And a lot of, like the Waltons are a great example. Sam Walton gave away Walmart when his kids were probably that big, because now all his kids are each worth $20 billion. So that tells me that they didn't pay the 55% estate tax that applied back then, that's what it is, that's what it was. They reduced it to 40%, and then Massachusetts can get you for up to 16%. So you're looking at 50 to 52% dollars for estate planning purposes. So if you don't give it away while you're alive, if you just hang on to it till you die, then typically you just write the check to the government, and it's usually a big number. So most estate planning gets done by gifting while you're alive to the next generation. If you're gifting stock in a corporation, you can get a little bit of a discount, but you can't get the discounts that you can get if you're gifting LLC shares. If you do it correctly and you use, let's say, a Delaware LLC, and you do gifting of shares down to the next generation, you can typically get a discount of about 35%, which is pretty good. So a dollar is only worth 65 cents. And when you do that over a number of years, you can save a lot of money that way. So when you gift stock, you're not going to get nearly the discount that you're going to get and then if you give LLC shares. In either case, when you do corporations, the other thing which I wanted to mention is the upfront documents for a corporation. Typically, you'll do a stock cross-purchase agreement, and that governs the rights and obligations of the various owners with respect to themselves, that I can't give my shares to certain people or sell them to certain people, that I have to basically offer them to my partners first and then maybe the corporation before it goes anywhere else. And typically, if you do plan on leaving your stock to the next generation, then you want to have a provision in the stock cross-purchase agreement that specifically allows you to leave your stock to your heirs, because otherwise, the general boilerplate ones say you can't. And the same thing with the limited liability company. You want to contemplate your succession planning goals in the operating agreement, because if you forget about it and leave it out, it may be too late down the road someday when you go to try and do it and your partners won't let you because the bus has already left the station. So that's all I had at this point. I guess Bobby Hazelton's going to be next.
How is everyone this evening? Are you picking me up because I try to move around? So hopefully it won't be. Okay, I won't move too far. I'll be a little bit locked here. As Kurt mentioned, my name is Bobby Hazelton. I mostly handle transactions that involve intellectual property. So I mostly deal with contracts and contractual relationships between parties. They asked us when initially we were getting some of the things in, there were some key things that I think that the audience was asking for, that they were looking for in terms of what to look for in these agreements. So what we've tried to do with this presentation is put something together that addressed some of those intro questions. What are you looking for in your agreements? What type of agreements do you want to get in? What are your red flags? But to get there, probably have to do a little bit of primer about what we mean by the concept of intellectual property and also what we mean by technology transfer. And judging from the questions that we've got here, I'll also let everyone know my background. Before I was a lawyer, I'm a second career lawyer. My undergraduate degree was in applied mathematics, and I mostly worked in the software and informational technology industries. So I've seen a number of software questions already come up, and we'll try to address those during the question and answer session. But again, to begin with, what are we talking about with intellectual property? Intellectual property is any type of intangible property, something that we can't hold, something that we don't transfer to each other, something that's a little bit more amorphous, that's created by mental labor. And usually when we talk about intellectual property, there are the big four of intellectual property. There's patents, which protect inventions. There's trademarks, which protect the origins of goods and services. There's copyrights, which protect expression. And there's trade secrets, which protect things that people keep secret. There's some business value, and there's something around that thing of business value that you use to keep secret. And we're going to talk about some strategies for that in a second. Usually, most of the time, people are talking about intellectual property. We are talking about those big four. We're either talking about patents, trademarks, copyrights, or trade secrets. There are a number of miscellaneous things. Some of them fit in conversations around the other four, but two that are sort of outside that area is one is the right to publicity. The right to publicity is generally a state law, and it's going to differ from state to state. But as sort of a general matter, most every person has a right to take economic advantage of their name and likeness. So the right to publicity is going to come in if you have some type of venture and you're trying to associate it with somebody else that's famous. Or when you get to where you're doing your advertising and you want to bring in your people to endorse your products. So the right to publicity can come in those types of situations. If you have something to where you are doing something that is sports related or that is related to providing some types of services, you may come across right to publicity. I'm not going to talk too much more about this sort of miscellaneous right tonight. The other is the right to privacy. In general, again, this varies from state to state, but it's recognized that everyone has a right to privacy. That there are some private things that if we at least keep them private, that we can keep from having some type of public disclosure. Now, we don't see as many right to privacy actions as what we used to. This was big about 10 or 15 years ago, where in the news media, if you have some type of communication company, where it was a big deal to sort of out people, to talk about what their sexual orientation is. But if you are in any type, if your business model is into anything to where you are going to be promulgating information about people, and particularly if those people aren't public figures and it's something that's not out in the public, you do have to watch for the right to privacy. Again, we're probably not going to talk too much about that. Important takeaway from all of these things. Ideas are not protectable under intellectual property law. Mere ideas are not covered by IP. Now, with that being said, we can usually get you one of your ideas to where they fit into one of these categories. And there's some other things that we can do about contract. Jess mentioned earlier the idea of a non-disclosure agreement, and we're going to talk about the utility of that non-disclosure agreement as it pertains to a lot of different intellectual property. You talk about some, but we'll actually spend a good deal of time talking about the NDA because there's a lot of things in there that may be protectable for your business. So let me talk about each one of them so you get an idea as to what we are talking about. And the first is patents. As I mentioned, patents protect inventions. We're talking about compositions of matter, products, processes, but not mere ideas. There must be some reduction to practice. We have to have something to where we could teach somebody else how to make it for there to be patent protection. Now, there are three major types of patent protection in the United States. There are plant patents, design patents, and utility patents. Plant patents cover plants. I don't know if we have any agricultural businesses here, but you can figure out a new way. You have some new sequence of corn seed. You can get a patent for that plant. Designs protect ornamentation. We're going to talk about that a little bit different as opposed to trademarks, which protect the origins of goods and services. But if you're manufacturing chairs, and you got a chair that's got some special look, maybe it looks like something from the 14th century, the design, the non-functional parts of that chair could have a design patent associated with it. Mostly, though, what most inventors are looking for are the utility patents. There are two different types of utility patents. There is a provisional patent and then the non-provisional. The provisional patent is a strategy that many inventors will use, and I'll talk about this a little bit more on the strategy side. With the provisional patent, what you can do is essentially you can stop the clock on the patent statute. There's a lot of rules about when you can get patents. But you don't have to file claims. You don't have to say what it is you're protecting, and you get a year to go back and file the non-provisional patent and be able to track back to the provisional patent as far as what your date is, at least for your date of invention. So many times it is a strategy. You're not necessarily going to be in a position. You've got something that's inventive. That's the core of what it is you're going to take to market. You're worried about protecting it. What you might do is just slap a cover sheet on whatever your drawings and information is, file it as a provisional patent, and buy yourself a year. Now, our office does not prosecute the patents. That's not the main focus of what I do. As I mentioned, I do mostly the contracts, which we talk about the technology transfer. But we can't help you with that. There are many attorneys that we work with that can help you prosecute the patents themselves. And everything that I just talked about, United States, if you want to get protection in other countries, there is the Patent Cooperation Treaty. There is a PCT process. We can work, our counsels that we work with can help you through PCT, and if need be, get sister counsel in other countries. But there are methods to where you can file patents here in the United States and then get worldwide protection in other countries by going through a few steps. Now, trademarks is a big part of my practice. As I mentioned, trademarks protect the origin of goods and services. The idea is it distinguishes your products from your products. And there's craft beer coming in a couple of weeks. Beer is an area where trademarks is really big. Maybe you've got some type of IPA, you've got another type of IPA, and you want the public to make sure they know your IPA as opposed to his. And it's all about branding, and that's what we're talking about with trademarks. Trademarks is different than patents. With trademarks, you do not have to do anything to get protection out of the gate. Patents you have to file with the government, and patent is granted to you. Trademarks, you use it with your goods and services, you will get certain common law rights. You also may be able to file state-level trademarks. The only problem with any of these doesn't help you very much if you're selling beer here and you want to go to New Hampshire. You're in New Hampshire tomorrow, the two of you conflict. Now you both have a problem, and there's a little bit harder to work out for that problem. So as a result, you can get national level protection. You can get the presumptive right that you're in all 50 states. The Lanham Act covers that. There's a registration process for that. You have a trademark before you do it, but you can get a trademark that is registered with the United States government. Lots of advantages to getting a registered trademark. Again, the biggest one we're talking about right here is presumptive rights in all 50 states. Like PCT, we can also go international with our trademark. We do have to always get counsel in other countries to do that. That's through a process that's called the Madrid Protocol. And when we're talking amongst ourselves, I kind of stopped the trademarks on those 3 bullets. But Christina pointed out there are many times that people get other types of name protection. There may be things that you do that protect some names that aren't necessarily the trademark protection. There's lots of different ways. There are registries that are out there that can protect names. An example that I think Christina mentioned, to us, want to make sure we mention to you guys, registering a domain with an ICANN registrar. So you register a domain name, it's going to keep other people to get the domain name unless there's a dispute. There are other things that are out there, label registrations. You're in the alcohol industry, you can go through label registrations. There's corporate name registrations in each of the various states. As Dennis talked about, you can file business certificates in various cities. And in some states, some of you may not be confined to Massachusetts, you can file business certificates at a state level or county level. There's other things that you may be familiar with too. Anybody here are musicians? There are a number of band name registries where you can go out, put your band name in, and it's one way that people actually track what are priorities of uses. Be careful with these if you ever do decide that you're going to get trademark protection, because there are a lot of scams that are out there. Once you're into the system, you'll start getting a whole bunch of things that look like they're official communications. They're trying to get you to sign up for the registry services, and really it's just a scam. You're paying a lot of money to be put in their book, and you're getting a real value for it. Copyrights. Copyrights protect expression. Now, I got a little bit of a heartache, I think, when I was putting this together, and I might make this too small for you, but the only thing that we're doing with this first bullet is talking about what the exclusive rights are under copyright. They're granted via statute. A copyright owner, someone that creates protectable expression, has the exclusive right to reproduce the work in copies and phono records, prepare derivative works, so in other words, like a translation, something that's similar to it, distribute copies and phono records to the public or transfer ownership, publicly perform whatever it is, and display the work publicly. And in the case of literary and musical works, also to be able to replay those if they are recorded mediums. Copyright, again, like trademark, you do not have to do anything to get protection. You will get copyright protection as soon as the pen leaves the paper. You write new software code. I know we've got some software developers out here from the questions. Soon as your fingers are up from the keyboard, you have a copyright in what you have written. It does behoove you, though, to get a registration because it is a little bit of a toothless right. Because one of the rights that registration gives you is the right to be able to sue in federal court. It also helps you establish priority if there is to be a fight about when copyright actually took place. The other thing, if you're dealing with expressive works, I don't know how many people here are not necessarily in software, that's a little bit less expressive and a little bit more functional, kind of on the, but if anybody here's into visual arts and works, now we got a producer here in the back. One of the things that you will run into are moral rights. They're really big in Europe, but they are protected in the United States. These are the rights for attribution and integrity. Integrity, real big probably about 30 years ago when people were colorizing movies. If there is an author, they can protect people from making improper derivative works. And attribution is the right for the author to be credited with the work. One of the things that's not on this slide, for that, it's one of the reasons why, agreement-wise, we try to make them works made for hire. And I'll talk about that in a couple more slides. That gets us away from the moral rights problem. It also gets us away from a problem in copyright, where if it's not a work made for hire, there's a period of time, it's a long period of time, 35 years, but where a copyright author has the right to be able to rescind any grants and licenses that they've made. So we do try to get to that work made for hire for that reason. Last of the big four is trade secrets. Chances are, unless you have a ton of capital, a big part when you're an entrepreneur of what you're going to have that's your valuable IP is your trade secrets. This is your know-how. This is your customer list. These are the things that you keep secret and try to put things in place to make sure that they're secret. Customer list. For the longest time, this was also a matter of state law. There was rules at each state. We had to battle with each state. There was a uniform law, so it was somewhat the case. But it was a matter of state law, and we had to chase around which law. There is now a federal Trade Secret Act, so we can avail ourselves of that. For you to be able to have a trade secret, there are 3 requirements. The information must be secret. That is, it's not generally known or rarely accessible to the public. It must have commercial value because it's secret. Coca-Cola formula being an example. And it must have been subject to reasonable steps by the rightful holder of the information to keep it secret. So it's got to be a secret, it's got to have some value, and you've got to do something that shows that it protects. And that being said, that's where we can transition from the sort of academic conversation to what is it can you do? And this is probably one of the most valuable tools in an entrepreneur's repertoire, which is the non-disclosure agreement. The non-disclosure agreement, you may have heard it called a confidentiality agreement, proprietary information agreement. Regardless of what the title is, it's the same document. What we're talking about is some agreement that has 2 key elements in it. 1, for people not to disclose information that they're given, and 2, for people, probably more important, particularly if you're not financing a patent, not to improperly use the information. Anything that's got those 2, there may be a bunch of other things that we'll talk about. We're going to call it an NDA, at least for the purpose of the analysis. And today, people trade these like business cards. And unfortunately, most of the ones that they trade, when they get them like forms, they're ones that are designed for mergers and acquisitions, not necessarily designed for some of the technology things that you may be doing. So there may be some gaps in terms of, and we'll talk about what those gaps are. But any of this is the NDA, and it's going to be one of the most powerful tools in your repertoire. It's also something that you can use for that trade secret protection. because you can use it to show that you are using reasonable steps to keep things secret. It's also, which is a little beyond this lecture, something that we can use to show there's a community of interest for any of the problems that we might have with copyrights, and is also when we deal with patents and what the patent statute is, and helping us be able to secure being able to have our sort of 1 year threshold at which we are allowed to be able to file our patent grants aside from the provisional. There are other things you will see in an NDA. What should scare you? What should you include? What should you not include? Well, there's going to be a lot of boilerplate. And chances are this boilerplate's going to be in every one of them. There's usually going to be a clause in there that deals with injunctive relief. It means a court can get people to stop doing things. Key things to look for there is, do they have to put up a bond and do they have to prove damages? Depends on what side of the deal you're on as to whether or not you want that to be. Do you want it to be easy or you want it to be hard? If you are the owner of the IP, you don't want to have to post a bond. You don't want to have to prove damages. You want to be able to go to court, get an order. Venue, obviously you want it in your backyard. You don't have to pay to go across the country. Choice of law, well, if you use us, we're going to recommend Massachusetts law. We do have attorneys licensed in other states. I'm also licensed in Arizona, but Massachusetts, we live here. It's going to be a lot easier for us. Probably be definitions of terms. And there'll also be a term, and this is going to be kind of important as to whether it's boilerplate. Some things limit the disclosure period. Sometimes they limit how long you have to keep things secret. So we have to look at that, and depending on your circumstances, as to how we sort of decide how we want to balance those interests. The other thing that you will commonly see is that at the end of the term, there's usually something in there that either demands the return of information or the destruction of information. This keeps stuff from being out there and being improperly disclosed, and is one of the other things that you can do for reasonable efforts. Now, NDAs, because sometimes that's the only thing people trade, you start getting overloaded. So in addition to seeing these types of things in an NDA, you might see all other types of things. And I went through some NDAs and I was like, okay, what have I seen in the last couple of years as to what people try to sneak in there? Some people are trying to sneak in export control language. Well, if you're technology, munitions, our software people, it's encryption, it might be a munition and you might not even know it. Intellectual property provisions, which we'll talk about what you want for IP, some people stick them right in the NDA. Competition provisions. You may put something or you may not want something in there that deals with whether or not someone can solicit your employees and even whether they can compete with you. So sometimes we start seeing some of these what we call negative covenants that limit what people can do outside of the information being disclosed. Sometimes the relationship itself has to be secret, and at other times what we might see a little bit rarely is there might be some premises type clauses that talk about what has to happen for safety. And if you're dealing with any type of hot tech, you got anything that's radioactive, you got anything that could be dangerous, potential tort liability, you might see the NDA overloaded to include those things. Now, we could, as Dennis said, we could probably talk about 3 hours on NDAs. That's sort of the overview. What you will want to look for when you're looking for them are the exclusions in the NDA, what is not kept as confidential. First, you're going to look in there and see is there any IP provisions. Is there anything in there that's going to make your work going to be part of somebody else's intellectual property or something that you cannot later disclose. The other thing is look and see what is in there that is outside what is confidential information. There are what I'd say 5 exclusions that you will see. Sometimes not all, sometimes many. You may want to give, you may want to get all of these depending on the agreement. One is information that's already in the public domain. Another is information that you already knew, and sometimes you have to prove it by writings. The other is some third party gives it to you without the obligation to keep it secret. Another might be independent development. And for those of you who are doing consulting and services in tech companies, that might be a very important provision for you. You may have different customers that are competitors. You want to make sure that you don't have a fight because each one of the customers are mad that you're working with the competitors and claiming that what you're doing is using their confidential information or even what is going to be their titled IP. And another one, and I'd say this should be in every NDA, is lawful process. You're going to need something that allows you to be able to disclose if you get a subpoena or something of that nature. These clauses get written a lot of different ways. You can look at them as to what type of protections have to be in place. This is probably one of the most legalese overwritten clauses that you'll see. But it's pretty usual to see some exclusion if you get a subpoena. The other thing, which isn't expressly there, and if you come back to where Jess says, why do you get a lawyer? Anything that you're going to use elsewhere. That's the most important thing when you sign these, because you're entering into a transaction that is going to limit your IP and may deal with what you can do with someone else's IP. And if you do that, if you're creating something, there's something that's a core part of what you do, you want to make sure that it's excluded from confidentiality provisions of what you don't have to keep secret, something that you may have already got put in place. There's generic ways to do that, but it's very good to do it specifically. Notwithstanding the above, the following shall not be considered confidential information. And you put in whatever it is that you don't want to be encumbered in any way. Definitions, especially when you deal with these forms, and when you deal with the attorneys that are going to come in, that aren't going to create some type of custom for you, definitions will be really broad. So that's the biggest thing you want to look for, because they're going to try to sweep everything into being confidential information. You may be on the side where you like that, but most of the time you're not. There's going to be at least some bilateral, or where you're on the, probably on the lesser side, where you're going to make sure that you carve out your IP so that it isn't part of these non-disclosure and non-use. Remember, 2 covenants. Non-disclosure, you can't tell anybody. Non-use, you can't use it except for how we deal with each other. Now, I've gone through all of that, probably a little bit fast, because we're doing a 101. So the next question is, okay, how do I decide which of this IP do I have? Well, you can call an attorney, and as Jess said, that's fine, but you'll probably rack up some legal bills for them to go through and figure out what you got in terms of protectable IP. This is the United States Patent and Trademark Office attempt to be able to do that. If you go to this URL here, this IP assessment URL, 2 questionnaires are there, a short one and a long one. Fill out the questionnaire, they'll give you back and they'll tell you, okay, here's your IP. This is what it is that you're probably going to look about protecting. And it's very useful for you because you're going to know, most people will go in and think they want patent protection, and really you got something that's more random. So you're going to be seeking trademark protection. You're going in, maybe you need patent protection, but you haven't got the budget for it. And maybe there's a time when you need to get the budget for it. You can figure out as to whether or not you can get trade secret protection. Now, ultimately, how you do that, once you get that, it's a business choice as to how you budget, what you want to go after. But there's probably some important things. The first is don't blow the patent statute. There's a limited period of time. It used to be 1 year from the first offer to sell. That's kind of got carved back down. It's kind of technical. Depends on whether it's 1 year from the inventor or somebody that's under contract to the inventor, which is where the NDA comes in. But you do not want to make sure that if you do have patentable subject matter, that you release it, either through presentation or something that's not pursuant to the NDA, so that you later can't come back and get your patent grants. Use copyrights and trademarks to extend your protection. Particularly if you can't do it at the outset, anytime that you're thinking about a growth move. If you do it at the outset, you get a lot more protection. If you do it with a growth move, particularly before you do your marketing blitz, you're at least going to be able to protect people from being able to come back and free ride on you. Cover your trade secrets and maintain confidentiality. Again, I bolded that one, underlined it. Make sure you got that NDA in your toolkit. And a lot of these things require notifications. Trade secret for federal requires certain notifications to employees. Copyrights, if you're going to rescind things, require certain notifications. You don't want to lose these statutory rights. And this is where it's a little bit of, minefield. It really is a little bit more something for us lawyers. So I think this is where we can help. We can come in and say, okay, you want to protect this. These are the types of notifications you have. This is the boilerplate that you want in your agreements. This is where you want to use your agreements. Technology transfer is another term of art that we use. It really sort of came out of the federal government. It was the idea that we've got in-groups, people that create IP, and we want to get that technology out to wider groups of people so that the whole society benefits. And in most government grants, if you do, any type of the government technology grants, having a plan for your technology transfer is going to be required. So I don't know how many of you are fundraising, but those of you who are seeking the federal grants, you're going to be having to think about what technology transfer looks like for you in your business planning. 2 key things to keep in mind. This actually happened today. I was explaining the difference. Grants and conveyances. 2 ways that you're going to move technology out into other people. One is by granting them a license. This allows them to use it. The other is assigning them all the rights. This is for the title. They are different things. And just like if you buy a house, you might sign a purchase and sale, then later do a deed. You sign a contract, you may have some type of provision that requires you to transfer, and then later you actually have to sign the document to transfer. Grants and conveyances get stuck in many different agreements, and that's what you've got to go through and look and make sure you know what you're giving and the scope of what you're giving, not what the title of the agreement is. It can be stuck in an NDA, it can be stuck in a services contract, it could be stuck in, in something else. So don't look at the title. we're looking for provisions. Look for words like assign, transfer, grant, things of that nature to see whether you've got any IP problems. If you do find these, the question comes back, okay, what do I keep and what do I give away? You're in these services agreements. You're going to have to bargain for it. Well, you want to make sure you keep your core technology until you hit your exit. Whatever your exit strategy is, you want your core technology to stay there. So you don't want to assign, sell, or convey this core technology. At most, what you're looking is granting a license, and in many cases, a non-exclusive license. You're going to make sure you're not giving up the farm and giving somebody else all of your core technology. If there is the word exclusive, whether or not it deals with the entire technology subject matter, or whether or not it deals with a certain territory, or whether it deals with a certain way of practice, evaluate that. When you see the word exclusive, nobody else can come into that area, not even you. So if I give you an exclusive license to France, I can't sell in France if you've exclusively got that territory. So watch out for those exclusivity provisions. Also, evaluate the amount of technology being transferred. Again, this is where people try to throw general words in there. Don't transfer what you don't need to transfer in order to have the commercialization agreement. If you've got, again, we'll come back to the idea of software. If you've got, 3 different, libraries of software, license the one they need, not all 3. There's no reason that everybody needs to get your whole kitchen sink. Even if it is some type of development contract for our software people, to where you've got somebody who's only dealing one part of the software. Don't give them a license to anything else, even if it's within the scope of the contract. Talked about the territory, and evaluate what your counterparty has to do with that license if you're just giving a license. Many times in there, you'll look for words like sub-license, assign, etc. Can these people give their rights to someone else? Usually you don't want that. And a license is usually something that's very personal. You've picked your service providers because you trust them. You don't want them using somebody else. So you want to evaluate as to whether or not there's a right to sub-license and whether or not there's a right for somebody to be able to sign their agreement. There's also protection mechanisms where you can isolate your IP from your operating company. Dennis talked about when it's prudent to form different types of entities. Sometimes we'll form an entity just to hold IP, and then we'll license that IP back to an operating company. I've got at least one client in the audience, and I know we've set up some models like that in the past. And that can help you, particularly if you're worried about infringement, tort liability. You want to protect your IP, which is a valuable asset, from what's going to happen from your day-to-day operations. All right, what do you want? We talked about what you have to give away. Well, you obviously want any new technology that's integral to your operations. You're going to go to somebody, you're going to ask them to build something, you're going to ask them to develop something. If it's integral to what you're doing, you don't want to be taking back a license. You want to own it. So rather than get the license, you're going to want to probably get an assignment. 2 key terms there. There is the background IP. This is what people own coming into the relationship. And there's the foreground IP, which is usually what's created as a result of the relationship. Usually, there's charts up here, background IP. As we talked about before, only license as much as you need to. And then make sure you're licensing enough to practice the technology if it's the vendor, unless you're given an unlimited license. If it's foreground IP, obviously you want to try to own it, but you might not be able to, and you certainly might not be able to get that vendor's background IP. So there's a little bit of trade-off into figuring out what people come to the table with, what's going to be created, and how what's created is going to be exploited. Many times, I did have a client once create their service provider, they create IP, but they want to create a library of that IP and resell it. If you're going to do that, you've got to own the foreground IP in addition to the background IP. So you're going to need to make sure that you're looking at what is coming to the table as well as what's being created in your agreement. And then what do you let go? Well, core technology you let go on your exit strategy. Whatever your sellout is, that's the only time that you want the core technology to go after the door. If there's foreground IP and you're dealing with a services company and you're not going to exploit the IP, you just need to use it, it's possible you may give it up to the service company. As I mentioned, some exceptions. If you're going to monetize your own work product, even if you are the service provider, you need to make sure you keep it, even though it's foreground IP. And if your client's needs are limited, there's no reason to give up the kitchen sink if they don't need it. Last, coming up, lots of different agreement types that you might run into for IP targets. Component purchase agreements, services agreements, engineering agreements. Usually, if you're doing component purchase agreements, you're going to see a lot of commercial terms that are under the UCC. There, you're going to look up enough of a license on background IP to be able to use, particularly if you're dealing with some types of embedded systems. Try to watch for any IP provisions on any of the non-recurring engineering if you're just buying components. Make sure you're adequately dealing with the risk transfer that's a little more commercial rather than IP. There may be inventory management provisions that you want in there to talk about how people are going to supply product to you. And then there's a lot of different boilerplate, which we talked about, because that could also be in the NDA. Services agreements, you may run into a lot of different types of these. Contract manufacturing, you may have somebody else manufacture your goods. You may have a quality lab come in. You may have a testing lab come in. Again, you're going to probably see a lot of UCC terms. There are going to be some inventory management terms. Here, you're probably going to want the ownership of the foreground IP. You're not going to get the background IP unless you run into a really small testing lab. And then you're going to see some of the number of things of risk transfer and inventory management. Big thing here, make sure your specs are pretty strong. If you're doing anything that is a services, you want to make sure that the other side complies with the services. And of course, we always have our boilerplate. Engineering, as I think Jess was talking about, even if you have like a lawyer, you want to make sure you want a strong statement of work. Make sure there's some type of acceptance criteria so that you figure out that you're getting what you need to at the end. Make sure you got strong specifications. Ideally, this is one where you want title. The sort of cliche around this is, hey, if I pay for it, I want to own it. But, see the previous slides. We talked about, that might not always be the nature of the transaction. There'll also be the risk transfer, the boilerplates, and the warranties that you'll also see into those agreements. That is a whirlwind real quick on risk transfer at IP. Hopefully in there what we have done is tell you what the targets are, so at least you know what to look for and how you might be able to plan before you go to your attorney what things are the most interest with you so that you don't get caught up into a long transaction. We will take questions. I know I've got a few already here, but if you've got any, feel free to pull them up. If not, I'm going to turn it over to Joe Bartulis, who is our employment expert. He'll tell you about how to do this in the context of bringing people in so that you can get around this work made for hire situation.
So good evening, everyone. I just enjoyed that quick course in all things IP. I wish you would have gone a little faster, though. I'm kidding. So thank you. Yes, my name is Joe Bartulis, and I will do, won't get into quite the same degree of detail, but I'll give you kind of the ins and outs as it might be, things you want to consider with regard to employment. It's no surprise to any of us that workers are one of your largest expenses, especially if you're a growing business. And so one of the things we want to do is kind of understand some of these concepts and terms. Okay, so real quickly here. So in Massachusetts, we have what is known as the Massachusetts Wage Act. I won't bore you with all the details other than to tell you it's found at MGL, Mass General Law, Chapter 149, Section 148. Now, what does the law provide? Effectively, the takeaway for you is this. All hours worked must be paid. All hours paid must be accurately calculated. All wages must be timely paid. And you have to classify workers either as independent contractors or employees. So real quickly, obviously, all hours must be paid, an obvious answer, okay. Must be accurately calculated. What happens is if you make a mistake, there's no dog ate my homework defense. If you don't pay people properly, you're going to get jammed up. And the key is the bottom there, treble damages and attorney's fees. So let's assume that I tell people, this happens, these are real life examples, where I tell somebody, you need to be here until 10 o'clock. And then because I'm working for a satellite of a larger company, I tell people, I'm only given so many hours that I can use, so I need all of you to punch out at 10 o'clock, but we're going to spend an extra 10 minutes getting the store looking good, okay? So that my hours don't look bad for the regional manager or the company. If you're a retail store, you're a business and you've got one of these, or maybe you're a franchise of something, if you've got any type of business. Paying people off the books, not paying people for doing any of their work, for any part of that, you owe treble damages, triple the amount that you should have paid them when you paid them. One of the most glaring deficiencies is when people don't pay overtime for hours worked over 40. They think, I'll pay you straight time for those extra hours and we'll all be good, right? And the fact is the law doesn't allow that. So that's one of the key things. Now, people often say, business owners and entrepreneurs alike will say, well, wait a minute, I've got an idea. I will pay that person as an independent contractor. And by paying him or her as an independent contractor, I don't have to pay time and a half overtime. Why? They're not my employee. I can still pay them an hourly rate, but they're not my employee. Well, that sounds good, although the law in Massachusetts is very strict on that. So I want to tell you that there's a three-part test. All three elements must be met to pay somebody as an independent contractor. So what are they? Okay. The first one, and it's contained in Mass General Law 149, 148B. The first one is that the person must be free from direction and control from you. People say, what exactly does that mean? In layman's terms, it means I give you a task and I assign you to do it. I don't tell you how to paint, move the brush stroke around. I don't tell you how to set the concrete. I give you the job of doing that. That's number one. Number two, this is the one that jams up most employers. You cannot have any W-2'd employees providing the same service that an independent contractor does. So for example, if you're an accounting firm and you're bringing in John Smith off the street to do accounting during tax season, and he or she is in the office or cube next to somebody else who is an employee, there you run the risk of being jammed up for that, because now you've got an independent contractor doing the same work an employee does. Now, beyond the scope of our presentation, but if that accountant is him or herself incorporated, now you're writing your check to a vendor, the incorporated entity, not the individual. But there are ways around that, but I just wanted to point that out. And the third one is the individual must be him or herself in an independent profession, occupation, or trade. Okay, so what does that do? That's usually met by most people. Most of the very people you'd be wanting to bring in as independent contractors meet that. But here's the key, is in the example of the accountant, that accountant is prepared, is ready and willing to do taxes for other individuals, right? That designer who's designing your logo, that person who's doing marketing for you, if he or she is a journey person and they do that type of service for anybody else who retains their services, they are in that independent trade or occupation. What you can't do is hire a machinist to work in the factory and have him or her making your widgets as an independent contractor, because they're not in a profession, occupation, or trade. But for standing at your machine, they're not doing this work. Okay, so real quickly, if I pay you as an independent contractor, people often have the misnomer. They think, we both agreed. I agreed to pay him as an independent contractor, and he liked that better himself because it got him a gross tax. So people think, because that's what we've agreed to, it's okay. No, they protect the individual from him or herself by saying, if those three elements aren't met, you cannot classify that person as an independent contractor, irrespective of what you think you've agreed to with him or her. Okay, so later, after the fact, what is the most detrimental downfall of paying somebody as an independent contractor? You're paying them straight time for 45, 48, 50, 60 hours. Well, 2 years from now, when the relationship goes sideways, what always comes out? That spiral notebook. And they say, you paid me for 48, you paid me for 52 all of these weeks. I should have been your W-2'd employee. That $55 an hour you were paying me should have gotten overtime for 5, 8, 6, 10 hours a week for every one of those weeks, and now you're subjected to a veritable, colonoscopy by the Attorney General's office, where you're now enduring this. They do these employee audits where they will do these. They want to see all your records because there's a record statute, which I won't bore you with, that requires you to maintain this stuff. Additionally, you will be assessed a fine for workers' compensation that you didn't have on the employee you didn't think you had. You'll have to pay into unemployment for the unemployment insurance you didn't provide to the employee you didn't think you have. And then there will be the penalties, the treble damages for the Wage Act. Okay, so people then say, okay, you've got me. I'm going to call this person my employee. What happens now? What do I have to be mindful of? And here's the takeaway. The default proposition is this. All your workers, barring certain exceptions, should be paid hourly. Now you say, wait a minute, these are professionals, these are others. We'll get into that briefly, and maybe they do meet the criteria. You can never go wrong paying somebody hourly. You can screw up if you pay somebody who should be paid hourly as a salaried individual. Now, it may very well be that in your profession, most of the people you hire are salary eligible. I get that. But when in doubt, keep in mind, the default proposition under the Federal Fair Labor Standards Act is that you would pay people as a W-2 hourly paid employee. Okay, so real quickly, and again, I'm giving you, there's more stuff here on the slides that we necessarily have time working with, but one of the things is, so I've decided to pay somebody hourly. What is the key takeaway from this slide? The key is all time they work must be paid. So if you've got an administrative assistant, a marketing person, any person who works for you, who is doing work at home, checking emails, you're sending the incessant voicemails because you had this epiphany at 2 o'clock in the morning that you wanted to send to him or her, that's fine to send it, but if he or she reads it and responds, or even just reads it, what am I supposed to be doing? Paying that person. So word to the wise, if you do have an employee and you have these communications at all hours, ask him or her to keep track of them and to you pay them for them, or alternatively, you tell him or her, I can't have you checking those things. I might send them in the wee hours of the night, but please don't check or respond to emails or voicemails until you're at work, when you're on the clock. Okay. So again, these are more examples here, folks. Real quickly, read them at your leisure, but the key is whether they work with or without your permission, work, and all work must be paid. Okay, so then the question becomes, all right, well, can I pay somebody a salary? I'll give you the brief overview on that, and the answer is yes. But to do that, they need to meet two tests. The first one is called the salary basis test, meaning they're paid a certain salary, and it's consistent, and it's not subject to being changed ever. And the second thing is that their duties fall within the ambit of one of the enumerated exemptions. The key, though, is you'll hear exempt employee when you hear the term salary. I'm using the term salary with a capital S, exempt salary. Some people say, she's salary, he's salary, because I give him $750 every week. Well, they may be salary, right? But if they never work a minute over 40 hours, what did you really do? You paid them $750 for 40 hours of work. That doesn't mean they were really salary with a capital S, exempt. Now, the term exemption should tell you in and of itself that exempt from the general rule of the Fair Labor Standards Act, which is pay everybody hourly. The fact that they're called exemptions tells you they're the exception, not the rule. So real quickly, what are those two things? Salary and duties. So I'm going to tell you real quickly, the salary is $455. Some of you may have learned a year ago there was a lot of brouhaha that they wanted to increase that salary by literally almost doubling it, and it was going to come into effect last December. It didn't, okay? But that's one of the things. Okay, so what do you need to do, assuming your salary meets the test? And unless you live in a very inexpensive place to live, and I don't even know where this would apply, the 455 salary test is virtually always able to be made. Okay, so that's usually almost a non-starter. But the second thing is, what are the exemptions? And real quickly, the exemptions are the executive, the administrative, the professional, and outside sales, okay? Those are the key ones. And the key one that you're most likely to come in contact with would be, of course, maybe the first three. But real quickly, what are they? There are, just like the IRS code, and it serves as a great sleep aid, but the Fair Labor Standards Act similarly has provisions in it that go into page after page after page of what it means to be an executive, an administrator, professional, or the other. I've boiled them down to one or two key points because that's all you're going to remember after you leave here anyway, okay? So real quickly, what are a couple of those key points? Okay, to be an executive, you customarily and regularly oversee the work of 2 or more full-time people, okay? Now, you got 3 part-timers. Is that the equivalent of 2 full-timers? Most likely, okay, but it's 2 or more individuals who collectively work the equivalent of 2 or more full-time employees. The second thing, and this is a key, that person has the ability to hire or fire workers. That's what we would call an executive. There might be 10 other elements that you can factor in, but if you have those 2, you're pretty good, you're in pretty solid ground. So if you're drafting a job description, what are the things you want to keep in mind? Exactly those points. You want to keep those things in mind and keep that in mind. Okay, moving real quickly, the administrative exemption. Won't bore you with the details other than to say the key is it's non-manual, and they oversee matters, they exercise discretion on matters of independent judgment, okay, on matters of significance. So we could have a debate about that. We don't have time today to go over what are matters of significance, but what is independent judgment. But usually, the higher the financial cost of the wrong decision, the more important the decision, okay? Okay. Under the administrative exemption, it never includes clerical work. You often hear a lot of times office managers at like dental offices and doctor's office, they pull those color-coded files off and answer the phone. They are not exercising independent judgment on matters of significance most often. Okay. The professional exemption is usually somebody with an advanced degree who's got some kind of a licensure. Okay. Outside sales, the only key you really need to know about outside sales is it's not on the road sales necessarily, or it is that, but it's not working remotely from the office. So if you work at home for a company that's a multinational company, you are not an outside salesperson unless you're actually out on the road. Okay. Okay. Now, I won't go into great detail with you on this, but one of the other elements I just want to mention briefly is there's a backdoor way to be an exempt person, i.e. paid a salary, and that is if he or she is doing largely exempt duties, maybe not 50.1% of their time, which is the other prerequisite, but a large part of their time to do that. You can meet this criteria if you're sufficiently highly compensated. The number is $100,000. Okay. Bobby addressed the non-disclosure agreements. I won't spend much time on them now, only to tell you that non-restrictive covenant agreements usually take the variety of a confidentiality agreement. Bobby spoke of that. They often take on the description of a non-competition agreement and non-solicitation. Non-competition is you can't do what I do. A non-solicitation is you can't solicit my customers or my clients, okay? And that's really, or my employees and my customers, clients, are the case may be. There were a couple things that I mentioned there, and assuming you meet all those other criteria, they've got to be reasonable in their terms. I've just pointed out a couple of them, and we want to get to the question and answer period, so I won't spend much more time on those, other than to tell you it's got to be reasonable in its duration, never more than 3 years, reasonable in its geographic scope, that can change depending on the nature of the business, and reasonable in the breadth of what one can't do. So for example, if I sell pharmaceuticals or I work for one of the large pharmacy companies and I'm a pharmacist and I signed a non-competition, but it says I can't compete within 10, where there's a multinational Walgreens, CVS, one of these other companies, whatever it may be, within 10 miles of there, I'm going to run out of state before I get to the 10 miles just because of the exposure of those places. So these are all kind of concerns you want to keep in mind. Thank you, folks, very much. We'll open it up now to questions.
Bobby, do you want to start off with some of the questions that you've received?
Certainly. And as mentioned, I doubt we're going to get these. I have 8 in front of me right now, so I doubt we're probably going to be able to get to all these. But I tried to order them to where I thought they might be the most benefit to the larger community, but I'll be happy to talk to anybody staying after. First one is, if I wanted to play music that I didn't own on my own company website, do I have to pay ASCAP and BMI fees to protect myself? For those of you who don't know, ASCAP, BMI, and CCAM are 3 different performing rights organizations. We call them PROs. They mainly deal with recording artists, where they collectivize, and you can go to these particular places and then be able to get the rights to take that and broadcast that, because one of the things is broadcast is publicly performed, is under copyright. The answer is it depends on exactly what you're going to do with that music. If you're just streaming the music like a radio station, then yes, you would probably want to go to either ASCAP, BMI, or CCAM. Any of them can have different artists. So if the artists are represented, whichever ones they're represented by, you'd want the artists from that company. If you don't know and it's going to be widely, used, you're going to have to get licenses from all 3, and you may have to get licenses from any unrepresented artists that aren't part of the PROs. So that could be, some individuals. So if you're planning on doing music, you might want to have a plan on what type of music is going to be used. The other sort of trick on that is it depends on whether or not you're just streaming or there's some type of audiovisual component. In addition to having the license from these performing rights organizations, there's a second type of license called, which is a synchronization license. So if you've got moving pictures and you're synchronizing audio to it. That license has to be acquired too. And unfortunately, there aren't a lot of organizations that compile those. So you may be chasing down individual persons, in order to do that. Unless you're a media company, my advice to most people, go out and commission your own music. That way you can decide whether or not that you want to own it. You're not going to have to run into what the licenses are when you renew the licenses, somebody pulling a license out over at the 35-year point. It's usually only the bigger people that have the budget necessary to track down licenses. So go out and commission. Find somebody you know that's a composer. Plenty of them local. You can probably find them in the papers. See if they can compose something, get them a service contract, and then you own the music. Do with it whatever you want to. But the answer to the question is, yes, you may need licenses from ASCAP, BMI, CCAM, from individual composers, and from who wrote the music for any of the synchronization licenses.
Dennis, do you have a question?
You guys have until 5 in the morning?
Just one of them.
All right.
We'll mix it up.
Individuals starting out of providing a service to a client, how do we benefit from a disregarded entity, single member LLC? If so, how? Again, this is, I think I started out with this, and that is, if you are one individual and you don't have multiple employees or people rendering services, then you're not protecting yourself from any tort liability, whether you set up an LLC or not. The single member, the only reason I mentioned the single member LLC was for the fact that the IRS allows you to not have to file a separate tax return for the entity, and you can just put the numbers on the owner's tax return. And potentially, I suppose, if you had contracts that they allowed to run to the LLC versus the individual without a guarantee, you could maybe protect yourself with some contractual liability. So I think that was the question that was it was actually asked about 2 or 3 different ways, but that's all I have on that one. Oh, hold on. Can operating agreements be changed once they're in place for an LLC? Yes, they can. Operating agreements, just like any other contract, can be amended, provided that all the signatories agree to amend it. Or if it says that this can be amended by a majority or unanimous or whatever, then you can obviously amend them just like any other agreement. But you might have other people involved, which if you don't have their if you don't have their consent to make the changes, then you might be stuck.
Jess, do you have a question?
I have one question. The question is, how are cost overruns handled, specifically when the statement of work fund has been exceeded? Now, I think this question assumes that the attorney is billing on an hourly basis. So, on the contrary, if they were billing on the basis of a flat fee, then presumably the statement of work would never be exceeded because you've already established the fee and there's a not to exceed limit. When you have an hourly fee, yes, there is obviously a possibility that the statement of work fund may be exceeded before the statement of work itself is completed. And this is when it's important to set your attorney's expectations. So when you're in that first initial meeting or down the road at whatever point the subject comes up, it's important for you to make it known to your attorney that you have a very particular budget. Beyond that budget, you're not able to provide additional funds. And then you try to sort of encourage your attorney to keep his work within that not to exceed limitation. Now, obviously, things might happen. The work may require more effort than was originally intended or originally estimated, and those are things that you sort of have to address when you get there. And if you haven't been clear with your attorney at the outset and said, this is, and agreed to a not to exceed limit for whatever statement of work you're establishing, then very likely the attorney has language in whatever fee estimate he's provided to you that says, this estimate is only an estimate, and the work may actually require more than is more funding than is being estimated herein, or something to that effect. So the attorney does usually protect himself in that instance. So again, this is just an example of where you want to be very clear with your attorney, set his expectations, establish that budget, and that way you avoid the conflict that might arise when the statement of work fund has been exceeded.
A responsive attorney in setting out an agreement such as that, and establishing a range on a fee, will often, if he's hitting the upper limits of that fee, contact the client and advise them and say, I just want you to be aware we've encountered these issues or these problems, and as a result, we have to date X number of hours. We had provided you with a quote of this amount or that amount. From our perspective, it's important to do that so that the client isn't surprised by a fee that far exceeds what they expected or what they were quoted initially, which creates a fee dispute ultimately between the lawyer and the client. And the last thing you want to do is be at odds with your client. So it's important, as Jess said, to have those conversations up front and for the attorney as well to monitor it. And perhaps on occasion, if you sense that an awful lot of work is being done beyond what you thought, to check in with the lawyer and say, hey, how are we doing relative to our retainer or relative to the quote that you gave me? Joe, have you got a question down at the end?
I do, thank you. So the question that was posed was, does using a third-party employment agency or service, staffing agency, help me get around some of the employment laws? And I guess the short answer is yes. If you use a staffing agency and you write a vendor check to the staffing agency, you've not hired individual workers, you've hired a staffing agency. But here's the rub, and I've seen this play out. You may have seen it at Mohegan or Foxwoods. One of those got jammed up on this a few years ago. The expectation is that the individual is a W-2'd employee of someone. So the expectation is that they're a W-2'd employee of the staff agency. So if you know that they're working 50 hours a week for you, and the staffing agency is charging you the same hourly rate for the first hour as the 50th hour, and neither of those captures time and a half, you know by implication they're not complying with the wage and hour laws. And so you could be jammed up if you're using those services. So the thing you want to do is make sure they've got their insurances and everything that's in place. But once you've done that and you're satisfied, that person, you can use, in fact, a staffing agency, as long as you know that they're W-2'd employees of theirs. If they can't be your independent contractor, you can't get around that by having them be the independent contractor of the staffing agency you've hired.
Yeah, I'll piggyback on Joe's too, just in terms of the IP perspective, is that when you get in those staffing agency contracts, you're going to make sure that that they're pretty tight, because usually the state, and again, it's going to vary by state, but we're talking about the Commonwealth right now, is going to have it as a co-employment relationship. And you're also going to be trying to figure out, what if I got this work for me for hire? How am I getting this IP title? So you're going to want that agreement with the staffing agency to set forward how title is going to take place and how those conveyances are going to get. It was a big part of my day-to-day, chasing people from staffing agencies that contributed to something where there was an assignment responsibility to someone else. And that can be very difficult, very expensive, and very time-consuming. So the staffing agency contracts are kind of important. Did you want me to get to the next one?
Sure.
All right, next one. What is the impact on trade secrets when an investor refuses to sign an NDA to have financing discussions with an entrepreneur? Does this impact the firm's intent to protect their secrets? Well, the direct answer is it does impact. Is it completely critical? Nothing has said the failure to get one NDA is going to be critical to whether or not that you have used reasonable measures. But it is one time to where you're not using a reasonable measure, and then you've got someone on the other side who could disclose something. They could disclose something and essentially destroy your patent statute, because you wouldn't be able to track back because they don't have an obligation of confidentiality. With that being said, answering the question slightly a different way, there's some angels that are out there that are persnickety. They're like, I'm not signing anything. I'm not paying any money for an attorney. But I've usually found this to be pretty few and far between. Most of the investment companies and most of the investors typically know that these protections have to be in place, and they're looking for you to actually have some type of IP portfolio. So you can usually work with them. They're not going to sign an agreement that says you can't use my ideas. They're not going to keep themselves from being able to invest with everybody. But you usually can have some measure of controlled disclosure and maybe a scaled back NDA, and let the other side drive. Let the investment company put their NDA in front of you, which is going to let them do a lot of things, which is, again, what we want to evaluate. How much can they do with what we're disclosing? And therefore, how do we want to roll out that information? So I think there's strategies to deal with that. You may run into the one persnickety people that will not do anything, and in which case You got a business decision as to, is the money worth the risk? But it can impact, and people can disclose, and there's no obligation for them to keep it secret.
Dennis, your next question?
Okay. By the way, I think I have everybody's email address on these questions. We're not going to get to all the ones I ended up with, but I'll do my best in the next couple of days to shoot out an answer to the questions that we don't get to. Same here. Yeah, I think we all will. So this question is, I'd like to create a board of directors for my LLC. Obviously, LLCs don't really have a board of directors. They have members and managers. But this person said that they wanted to call in business leaders and have a relationship to kind of advise. The board would not be binding. Are there any legal concerns with creating this board? I would say no, because this board sounds like it's just advisory and it's not binding. So you could certainly do that without creating any liability. So yeah, I think you can do that.
Joe?
Yeah, thank you. So, a couple quick questions. So, it's kind of a two-part question. The first one was, are there certain exemptions for real estate salespeople or brokers other than the outside sales? And in fact, there are. So, beyond the scope of this, I'll email whoever the question was, but there are some express exemptions under the FLSA. Another one had to do with hiring interns, okay? Interns, it's very precise. I'll shoot you an email. There's about 8 or 9 things that one wants to consider when using interns. The biggest one, of course, is that it's part of a field of study, so through an educational program, and that they're doing something to gain experience towards that. So contrary to the Seinfeld episode, working for Kramerica, whatever Kramer's company was, where you're picking up the dry cleaning and doing other things, that would not qualify for an intern. Okay, so, and I'll shoot you with an email with kind of those elements.
Bobby, your next question?
Sure. Using open source. My app sits on top of open source. If I isolate what I code from open source parts, should I worry about copyleft, copyright, that sort of legal matter? So let me do some definition for some of you there, because there's some words there. Open source software is just a model of the way some people distribute software, where they retain the ownership. And in return, the license that you get, the ability to be able to use it, requires you to keep the source code disclosed. So in other words, you have to not only take the object code, what actually runs on the computer, but what the programmers put together. You actually have to publish that if you use the software. Copyleft is was sort of a neat phrase. It was actually developed by a Boston attorney that came up with the idea that instead of having a copyright, we're going to keep this copyleft so that we can control this and get this stuff out into the public. So that's just a licensing model when they talk about copyleft, and there's a number of different specific licenses that may be used. There's a Berkeley license, there's a Common Core license. There's a number that are pre-written that people can distribute things to. What this person's talking about is generally you go get the open source and you use it. That's what it's out there. People want to use it. They want the community to grow. But you're going to develop some software that in some way interacts with the open source software. If you do that, the question is, what have I got to worry about with my software? Well, rarely are you going to have to worry about title. You're still going to own it. The problem is, this is what we euphemistically call taint. What can happen is as a result of using the open source software, your source code can become tainted in such a way that it also must be distributed with an open source license. So that you're actually going to have to make your you're not going to be able to have sort of the secrecy by compiling your code. You're going to have to go out there and show the world how you wrote this, and then essentially somebody else is going to be able to write it. Do you have to worry about when it sits on top? That's a question where probably I would need to sit down with you to figure out exactly what you've used and what we mean by sitting on top. There is one license model where if you link the libraries, whatever libraries you linked, whatever code's touching that is tainted, and it would then become open source software. If it's something that's completely separate and divisible, and you're just running open source over here and you're running something else entirely different, chances are there's not going to be any concern. But it's rare that if you're using the open source, you're not at least linking the libraries, doing something with that open source that has the potential to taint. So we'd have to look at the specific license that the open source was released under, and then specifically how your code interacts with that code to determine as to whether or not you would also have to release under open source or do something else squirrely and crazy, because they have all kinds of little weird provisions in some of these copylefts.
Dennis?
Okay, so I have, let's see, the question is, I've created a Massachusetts LLC. Should I dissolve that and create a new one in Delaware? And I guess my answer would be, well, first of all, Massachusetts and Delaware statutes are really very similar. The only distinction would be that if you wanted to use the LLC shares to do gifting to the next generation, you can't use a Massachusetts LLC to achieve the maximum discounts that I mentioned earlier. You really have to use a Delaware or a state statute that's very similar. In any event, you can certainly set up an LLC in Delaware, and you can merge the Mass LLC into the Delaware in one transaction. So that's the way you'd want to do that.
You want to take another one, Dennis?
Sure. Can I cover nonprofits and B corporations? I'm not sure what we want to talk about as far as nonprofits. Nonprofits are, in Massachusetts, they're created, they're Chapter 180 corporations. There's a separate statute that specifies if a nonprofit wants to incorporate, then essentially you'd either do a trust, which was the historically way you do it, or a nonprofit corporation. So you incorporate with the Secretary of State, and then you have to file an application with the IRS for recognition of tax-exempt status. And if you convince the IRS that you're doing public charity type work, then the IRS will bless it and give you a nonprofit status. There's a lesser level nonprofit called a private foundation, which is almost as good but not quite as good as a public charity. And I can't say that I'm very familiar with B corporations. I know they're special purpose corporations. I think Massachusetts does allow them. I think there's 10 or 12 states that don't allow them. But I've never really done much with them.
Bobby?
At what phase of a project should an entrepreneur be concerned with existing patents? In the beginning or when the project is ready for commercialization? And, and Jess may even be able to chime in on this. All things being considered, if there's not any type of budget issues, start your patents right at the beginning. Many times what you're going to have from our last question, you're going to have people that might ask you to sign squirrely agreements, and you're not going to have any negotiating leverage. So the patent's going to be there, and maybe the grant's going to be there to protect you. Some of the investors, depending on what round you are in fundraising, some of them are going to be looking, and the basis of what they're going to give you is do you have your manufacturing contracts in place? Do you have, your IP protected? So some of that's going to be the commercial value for you to get the investment. With that being said, it's the most expensive part of IP protection. And again, it's something that we farm out. So, that's always going to be, a tug of war, as to what you do, budget-wise. If you can, start early. I'd highly suggest that IP assessment tool so you know what you got. If you are in a situation where you haven't commercialized, but you're not disclosing this, you're working in your basement, you haven't got anything to tangible form yet, no need necessarily to run and get a patent if you don't even have anything that's patentable. But if you got an invention and you got the money, get the patent, or maybe even, talk to somebody to get the provisional patent to buy yourself a year if you think you'll be in commercialization within the year. Problem when you do that provisional patent, the clock then ticks. And, at that particular point, you've got to get to the utility patent within a year, and your fundraising rounds might not line up business-wise with what you want to do. So I think it ends up being something you probably want to sit down with your attorney and have a good idea as to what your capital plan is in order to be able to make that decision. And if capital is not an object, then yes, go get the patents as early as you can.
Thanks, Bobby. I think we've pretty well exhausted our time this evening. I'd like to thank you all for your attention, and thank you, folks on the panel here, for your presentations. In closing, I'm just reminded of the words of Vince Lombardi, probably one of the most inspirational coaches in sports history. He said that the price of success is hard work, dedication to the job at hand, and determination that whether you win or lose, you've applied the best of yourselves to the task at hand. To apply the best of yourself to your goals and aspirations, you need advice from proper professionals, and guidance of legal counsel, as well as others. We here at Fletcher Tilton stand ready to assist you and answer your questions. Bobby and Dennis weren't able to get to a couple of your questions each. I think each had a couple left, but you supplied your email, so they will get back in touch with you and to provide that information. And we will stick around for a few minutes afterward in case there are any specific questions or you want to talk to any members of the panel. But thank you. We've been delighted to be here this evening.
Thank you.
Right, and thank you, and I'd like to get a big round of applause to the whole Fletcher Tilton team